Hello, everybody. Welcome to another session of Lunch and Learn with GEO. GEO, that's me. Okay. Today we've got a very interesting topic. We've got a very well-known lawyer who practices nationally. Maybe he'll tell us a little bit about the case he's working on right now in Miami. But we've got some housekeeping items first. We are recording, so here's the obligatory disclaimer. If you don't want to be seen, like Kristen doesn't want to be seen, you could shut your video off. And I'm going to remind you that please mute yourselves so we don't catch you coughing or choking. We have the chat box for questions. If you want to post to any social media, please use this hashtag. The next Lunch and Learn is October 26th. We're going to be talking about the metaverse. Imagine that. Here we are. Could you have imagined 20 years ago, maybe even 10 years ago, that lawyers are going to be talking about the metaverse for CLE, but that's what we're going to be doing. CLE credit is offered if you're a member of the NWSBA. I'll give you instructions on how to get the CLE credit when we're done. And with that, I want to introduce our speaker, Patrick Hammon. He's from Silicon Valley. Imagine that. How about that, guys? Here we are out in the boonies, and we've got a lawyer helping us, educating us from Silicon Valley. It's amazing what technology has done. He's done a lot of work in technology, and I don't know, Patrick, if you want to give yourself any other kick in the pants about what you do, please help yourself. Patrick is right now, he's speaking to us from a hotel room in Miami. He's there on a case for depositions involving two venture capital firms that are duking it out. So with that, I'm going to stop sharing, and we're going to get some help if Patrick wants to share.
Perfect. Yeah. So nice to meet everybody. GEO, thanks for the very kind and thoughtful invitation and introduction. My partner in crime, Amanda, is going to pull up our little PowerPoint to steer today's conversation. Just by way of background, everything GEO said, as I expect is usually correct, was true about me. And I appreciate the very nice introduction. I worked at Skadden Arps for 15 years when I started my career. It's a mom and pop firm based out of New York. But I ended up changing my career focus by going to a more trial-oriented firm that allowed me to develop my own book of business. I'm 40 years old. It was a little bit harder to do that at Skadden when I was billing out at, I think it was $14.50 an hour, when I was talking to folks in the Silicon Valley about potentially retaining me. And so far, it's been pretty exciting. I think, as GEO's bio pointed out, I do a lot of different and interesting things that I wasn't able to do at a big corporate firm, ranging from street crime to big venture capital disputes like the one GEO referenced. And just to put a pin in that, I'm down here in Miami. This is not expected. I was talking to GEO before folks got on the call. It's a very interesting dispute between two big funds where there's a lot of personality disputes between the founders. A lot of people run in the same scene and are friends with the same people. And there was a line of cross-examination or deposition questioning yesterday about who was in whose wedding. And I was mentioning that to GEO. I just was like, what is going on here? But there was a lot of text messages in this case, because as one could expect, when personality disputes sort of affect a litigation or add a different dimension to it, a lot of personal communications become much more relevant. And I think we all know that there tend to be more personal communications that go through text than through email. So that's just a little preview and a little bit of background. My dad's a lawyer. He has not been practicing as long as Nikki has, but he's been practicing for a bit. And I have three brothers who are lawyers. So our family's not creative, and we're pretty boring around Thanksgiving. Amanda, could you go ahead and pop to the next slide here? So this is going to be a little bit of an outline of what we hope to talk about today, but I think, as Geo said, we're going to keep it a little informal, and I'm probably going to learn more from you guys than you'll learn from me. But this is sort of where we intend to go, if that's possible. We want to talk a little bit about preservation obligations, but we also want to contextualize it a little bit and talk about, strategy as well, because there's different things that I think a practitioner should be thinking about when they're analyzing these questions, not just what they need to do in order to avoid being sanctioned, but what they might think is strategic to do in terms of bettering the positionment of their case and their client. So Amanda, if you could pop to the next slide, that'd be fantastic. So as Geo mentioned, I am out here in the Silicon Valley, and I have to tell you, there are new social media communication platforms that pop up by the second. I mean, literally, there's incubators I represent, and probably once a month I hear about 10 to 20 different companies that are trying to be the next social media platform. And every social media platform, or virtually every social media platform, has a communication angle to it, right? They all do. And so gone are the days of being able to neatly categorize what we have preservation obligations regarding, and things that we might want to use in litigation into just a couple different buckets. We tried to do it here. We tried to have 4 or 5 different general categories to steer the conversation. But even this might be arguably a little dated. I represent Roblox. Roblox is a really interesting app where young folk are able to develop their own version of the game. It's literally, there are blocks in the game and they can create their own games. And some developers who are kids can even make money monetizing those games. So why did I bring that up in this context? Well, it's a game, but there's a chat feature in it. And though I haven't seen people preserve or have debates about communications that take place in that space, not to be a downer, but there have been government probes or regulator probes about sex abuse that's been triggered, or that's been facilitated through Roblox, of all places. And my client is one of those clients that puts its hands up and cooperates with law enforcement as much as possible, and I think is a great corporate citizen. But when I first got that call that, wait a second, they're looking into this type of behavior on a game, on an app that literally is just supposed to be a game, it just kind of blew my mind. Again, not to be a downer, but it is a reminder that there's a greater proliferation of these apps and communication methods on phones, there's just more things that we need to think about. And Amanda's next slide, I think, might make the point a little bit better. It really has become a little bit of a game of whack-a-mole. I'm 40 years old. I think I'm pretty sophisticated about Silicon Valley. I probably know about half of what these icons represent. And I think if we did this presentation a year from now, there probably would be 20 different icons that are up there. But the point is that we are having different types of communication channels pop up all the time. And I think the prudent litigator wants to think a little bit about that. And I want to highlight one particular point here, because you might be thinking, Patrick, this isn't really interesting. This isn't really helpful. You're just identifying a lot of different communication channels. But one of the things that I've learned from this exercise, and I think just from doing my diligence in this space, is that you really need to know your client. Right? Just because we have 25 different icons regarding 25 different communication channels on the slide doesn't mean that you suddenly have to be preserving data in all of those different channels. But the thought is, try to have those conversations with your client early. Try to have those conversations about, what methods of communication are they using? I had to text.
Hey, Patrick.
Yes, sir. Yes, sir.
Asking this of a defendant, do you ask each witness in the deposition, what if they subscribe to or participate in any of these channels?
Yeah, I'm glad you brought that up. I think when I am on the offensive, yes, I will do that. And sometimes it's a little bit of a flex. It's a little bit of a show, because I'm not going to dig that deep, with a peripherally relevant admin to find out if she has ever been on a dating app. And I know that's not what you're saying, but I still might ask the question to try to get a sense of the landscape, because you never really do know where the critical material communications are going. But I absolutely recommend that, including in your early set of questions for a witness, like, how do you communicate? And I would recommend you do that internally as well, just so you have a good sense of I want to say where the bodies are buried, but I know looking at this distinct collection of lawyers that we only represent prestigious clients that have never done anything wrong. But I would put an exclamation mark behind one other concept that I think Geo's comment implicated here, which is the classic goose gander rule. The moment Geo we start doing that and we start asking about dating app communications of the CEO's admin, they're going to do it right back to us. And one of the trends that I'm seeing, at least out in the Silicon Valley, is sometimes there's almost like a mutually assured destruction that is understood by in connection with what you're requesting in discovery. In other words, sure, it's tempting for the right hand that's handling the offensive discovery of a campaign to go out there and say, I want every Slack communication that you've ever had. But on the other hand, there's also a perspective that that if that boomerangs back at you, it's going to dramatically increase your preservation costs and responsibilities. I think we all know on this call how expensive the act of collection is and the corollary act of review is. And so what I am noticing is that there are these sort of informal conversations that are happening early out in Silicon Valley, formally happening in connection with the 26F conference, but informally in state court as well, where we're saying, like, really what's in play. And, you know, my view, this is not something I've seen codified, but it is that if you have that sort of reasonably diligent inquiry that you've done at the beginning, you're protected. You're going to protect yourself when you then enter that conversation and say, here really are the pockets that we should be thinking about.
That's a good point.
Well, thank you. Amanda, could you flip to the next slide if that's okay? This is a highly scientific, mathematically precise graph that Amanda and I spent hours preparing, but the R coefficient for the math geeks here is 1. It is that linear and predictive. But the point of the graph here was to illustrate something slightly different from what we were just talking about, which is that as the informality of a communication medium goes up, so too does the litigation risk. And I think we've all seen that in our career, right? Going from letters and memos to email was just a shock through the system. I worked on a case back in 2007 that involved, it was a backdating case, a stock option backdating case that centered around events from this 2000 to 2003 time period when people really in the Silicon Valley were not used to email. And I can't tell you how many times I saw people say, like, make sure we don't put this in writing, which was, you know, just the ultimate irony as you're putting it in writing. Or, you know, make sure you delete this email, or, you know, conversations to that effect. Well, I think a lot of our corporate clients and a lot of just savvy clients in general have sort of an awareness that, you know, email is discoverable. Email is something that has a level of formality, a little bit more than letter writing, just as an example, or memorandum writing. And I think people are sort of a little bit more cautious. As you move up the curve and you start talking about text messages, you start talking about Slack comms, you start talking about Discord messages, which I'm going to talk about in a second. The level of informality and the amount of caution that we use when we communicate goes down, and that creates more risk for a million different reasons. I do a different conversation MCLE about like training about what to put in email and whatnot. And, you know, we focused on some of the really problematic emails we've seen in litigation. And I think a lot of people are getting more and more savvy about some of the red flags, right? You know, don't talk about deleting documents. Don't outwardly say, let's take this conversation offline. Don't use hyperbole. Those general rules of thumb that I think corporate America and people in general are getting a little bit more savvy about go out the window when we're talking about, hey, let me just pop you a quick message on GChat. So again, highly scientific, mathematically precise graph that I hope illustrates the point, which really is that as you're searching for discovery, offensively, affirmatively, be mindful of the fact that sometimes the smoking gun is not going to be in the email, but it's going to be in the Tinder message. And I'm not exaggerating. We've seen cases where there are Tinder messages where people are talking about how guilty they feel after leaving a company and downloading some documents on their way out. And again, you can
on Tinder,
yes, which is I got married and started dating before that revolution, so I don't 100% understand it, but what the young folk like Amanda tell me is it's a way for young people to meet and date and communicate, and we literally have had a case where one of those messages ended up being material, a smoking gun. And then defensively, just flip the coin, right? You want to be thinking a little bit about where your proverbial bodies are buried, like we mentioned a moment ago. And you'll see in the concluding thoughts, not to jump not to skip too far ahead. One of the lessons that I've learned in just having these conversations is the importance of being proactive and thinking a few chess moves down the board. And so if you're providing good counsel to your clients and you're talking to them before litigation and before disputes, you might want to think about this curve for two reasons. One, do we want employees on these platforms? Sure. Convenience. Sure. It speeds things up. Sure, it adds a layer of efficiency. But given the fact that it also comes with some of this baggage, is it something we really want to be encouraging? Is it something we want to put within the scope of our potential discovery obligations? So, having that sort of consigliere hat when you're talking to your clients, like, hey, I get that everybody's texting. I mean, I think we would be kidding ourselves if we said that, we strictly abided by the boundary between our work phones and our personal phones, right? I mean, how many people have even us as lawyers, who should know this better than anybody, have lamented a late night filing on their personal phone, or who have just out of the interest of efficiency texted an associate or a partner, we really need to get X, Y, or Z done. Malpractice action, all that's fair play, right? So having those type of conversations with clients and with the team early, we think is.
I think you cannot underestimate that. People have to be aware with their clients and have the conversation with their clients early on about how they're communicating, what they're using, and then there's the preservation point that you raised.
Absolutely. And I want to, Amanda, if you could pop to the next slide, there's one on the preservation point that GEO was mentioning. I literally didn't even understand what Discord was, but again, it's one of those things that the kids are using. And Discord is another one of those encrypted communication tools, but it includes video and audio. So let's take a step back. In the spirit of efficiency, employees at tech companies are shooting little audio messages to one another. Hey, make sure that you improve the spec 2.0 by adding this line of code. Audio right back. Sounds great. Think about what GEO was just talking about. The preservation cost can be tremendous. And there's competing considerations, right? I think some people on the call might have the knee-jerk reaction that I first did when I was looking at Discord preservation challenges, thinking, well, let's just as a matter of course, have an auto deletion policy so we don't have to take this on in the first place. We're going to talk about why that might not be the most prudent decision on the face of the planet in a moment. This timeline, again, this is informed by historians from Berkeley and Stanford in my backyard. It's historically accurate. It's scientific. It's been peer reviewed, but it's meant to illustrate a couple different things. One is that email revolution that we just talked about. Now, sure, email has been around for a long time. Didn't really change the way trials took place, I think, as the group knows, until probably we got into the 2000 periods. Some of my mentors out here who are like the old school white collar criminal defense attorneys often lament the proliferation of emails. And they say the center of gravity or the balance of power with respect to white collar crime has changed because of email. Because before email, there just wasn't an email, there wasn't a documentary record. And so with scienter being required with respect to most white collar criminal offenses, it came down to a he said, she said. Well, suddenly with these emails that are out there in the universe where people are saying, like I was mentioning earlier, delete this, scienter becomes a lot easier to establish through circumstantial evidence. I'll double click on backdating just because that was such a big part of my early career. That this was a practice that was huge in the Silicon Valley when it was first taking off. And nobody really cared. Nobody cared until a professor from the University of Iowa wrote a paper called Lucky Strikes. And he was talking about, it's just interesting when you took all public information about Section 16 officers from the Silicon Valley and took a look at their stock charts. It's just interesting how lucky the strike prices were for all these CEOs. Somehow they always got the trough. And that led to, people probably on the call remember, criminal prosecutions, shareholder actions, class. I mean, it just was this explosion. But one of the early cases I worked on was Brocade. And there was a huge discussion about whether people knew backdating was wrong. And you could imagine pre-email how much easier that would be to prove as a defendant. You could just have the defendant come up. I didn't know it was wrong. Well, we had emails. We had emails that we had to deal with where executives were saying that we're not allowed to do this. So anyway, center of gravity changes around the middle of this timeline. And it's changing as we speak. And the next two major inflection points are the explosion of social media that we talked about a moment ago. but also Zoom. And I want to talk about this a little bit in a second. Zoom has chats. I don't know if anyone's seen this before, but we had a case where someone was coaching a witness over a Zoom depot, not recognizing that the transcript comes right back to us as the administrator of the Zoom. So for those of you who are saying bad things about me right now, that I talk too fast or I'm too cheesy, know that GEO can see it, and it is potentially discoverable. But
yeah, and that reminds me, nobody's used the chat line yet.
Yeah, so don't be shy. Don't be shy. Even private messages are discoverable. And so the point is, if I were to make one more graph that sort of illustrates the point where we are in this new age of sort of working from home and being a little bit more pandemic minded, I think people are having less one-on-one physical communications. And what that means is the communications still need to take place, but they're taking place in a digital setting a little more frequently. So I don't think we can be an ostrich anymore. I don't think we can say, hey, we represent IBM or Intel. They don't use Facebook to communicate. Everyone is using social media, text, and non-email electronic means for communicating. And that's what this is meant to sort of signal. Amanda, if you could pop to the next slide, that'd be awesome. So common case types involving cell phone and social media data. When we first did this presentation, it really was about pre-COVID. It was really focused, I think, about, or when we were first having these conversations, there were two major areas that we saw text messages being especially relevant. One was in employment cases involving varieties of harassment of allegations. And the other was trade secret cases where there was something nefarious that was happening. And we found that those were the hotbeds. And again, what does that mean? That means you as good corporate counsel who's being a consigliere and proactive should be talking to your clients about those type of communications in the first instance. It also means you on the plaintiff side should be thinking about, hey, we got to get those types of text messages. That's probably where the guy is hiding his secret messages about downloading documents because he's.
Well, I've got a case right now, an employment case right now, where the plaintiff was complaining about people communicating about her on using text messages. So we issued subpoenas to her coworkers, and we got the text messages between the coworkers and the plaintiff was sexting to her coworkers and then complaining about sexual harassment.
That's as a plaintiff, that is game over, right? I mean, that is
exactly.
And so I really appreciate the real world example of what we're talking about. Those I still think are the highest level or highest areas where this type of communication is going to be relevant. But now, just moving back to what I was saying a moment ago, everything now has a text message component. Like I mean, the venture capital case I was talking about to start this, I mean, probably 50% of the documents that were shown to my client were chats were text messages between the two founders. So it's difficult now to say that there are cases that don't have this intersection. And why does that matter? Well, it matters as a plaintiff, like Gio was just talking about, but it also matters as a party who's thinking about preservation obligations. So with preservation obligations discussed, Amanda, maybe we can go to the next slide. Do you have that, Amanda? And okay, cool. So I think people are generally familiar with preservation. I mean, who isn't at this point? But let's talk a little bit just at a high level about timing and then about scope. Now, I wish there were hard and fast rules. I think all practitioners do about both of these issues, but unfortunately, there really aren't. We've surveyed the case law, both federal and state, pretty closely, and it's really hard to divine or develop hard and fast black letter rules here. It is unfortunately an area that involves a lot of judgment. So I think everybody, let's talk about timing, for example. Everybody knows the general standards in federal court about when the duty to preserve kicks in. It's when you reasonably anticipate a likely commencement of litigation. And I think that sounds fine and dandy, but what does it mean? And we've seen cases where even demand letters are not sufficient because they're directed to the wrong party, they're directed to the parent or to the sub, or they don't specify the appropriate type of allegation. Now that it's a fraud case, but they end up suing for UCL, which is a big consumer protection statute out here in California. That doesn't mean you should try to find refuge in being cute and over interpreting a demand letter or a preservation notice, but it does mean that when you're on the other side, you should be inclusive in the way that you're characterizing what you're asking to be preserved and to whom it's being addressed. But it's an area that that I think is easier to navigate when there is that initial demand letter. But how do you navigate it when you just can kind of sense, and we've all been there, you kind of sense when your client gives you a call, there's something a little funny going on, they're 30 days behind on payment. I don't know. Nobody said anything about the goods being unsatisfactory, but there's something in the air. I can just feel it. Is that sufficient? Again, it's really difficult to evaluate, but I think we as good practitioners probably should err on the side of caution. Now, state courts can be a little different. Admittedly, I don't know Illinois law here, but just so you have a fun fact about California, we don't have the same rule as federal court does. The trigger is when actual discovery is served. Now,
Wow.
that does not mean that a court will look kindly on the mass deletion of evidence after a complaint is filed. It just might mean that sanctions are less likely. Now, one question that I've been mulling around, and I cannot find the answer, but I'll tell you what I have found that fits into this timing concept is, does the obligation ever end, and when does it? How many times have we seen that, right? You get the nasty gram from the departing employee saying, we have claims, et cetera, and then you don't hear from them for a long time. Is it the statute of limitations? I've seen people argue it, but I haven't seen courts endorse that as a hard and is it the tolling or expiration of the statute of limitations? I've seen parties argue it, and I've seen that work successfully, but I have never seen a hard and fast rule in any court that the expiration of the statute of limitations is a per se rule or is a per se deadline upon which you can end your preservation.
So Patrick, are you saying that the preservation obligation, then you're looking at it that even if the litigation goes for 5 years, that preservation still is required?
I'm saying something that might even blow your mind even more, which is, let's say the litigation doesn't even start. And let's say the preservation notice or demand letter came in on year 1 and it's year 6 and the case hasn't been filed. I'm saying I have not seen a per se rule that says that as a matter of law, because the statute of limitations has expired, you no longer have a preservation obligation. Courts are analyzing this question through the prism of reasonableness. So I've seen litigants argue that successfully, but I have not seen anybody articulate that as a black letter rule. It's judgment. There are cases, and again, there's not a lot of action here. There are cases I've seen out of district courts in New York that talk about how once it becomes like, you can picture that reasonable likelihood evaluation almost as a curve. And the idea is once it becomes reasonably likely that litigation is not going to be filed, that your preservation obligation may expire as well. But it's a tough area that I think is starving for more guidance, because I mean, I literally have so many of those like ghost or zombie cases that are sitting in my file when somebody leaves one of my clients, or when you get a nasty gram from someone your commercial partner, and you wonder, does this mean I need to do this forever? And clearly that answer has to be no. But the case law that I've seen doesn't give you the clear guidance that today is the day you can throw your hands up and celebrate. Now, there could be a practical answer here too, which is, well, if the statute of limitations expired, what are they going to do, right? How are they going to, in what context is the claim of spoliation ever going to come up in? And so there could be a practical way of answering the question when clients are asking you, do we still need to preserve documents from 15 years ago when that random commercial partner sent us, a nasty gram? But again, as far as just the academic question of when your preservation obligation suspends or terminates, really, that's not something that's been navigated or answered definitively by the cases or by the courts. Scope. So we talked about timing, scope. Not a lot of dispute here anymore. It's kind of becoming an easy call now that text messages, Slack communications, anything with a direct or even peripheral nexus to the subject matter of the litigation is within the scope of what needs to be preserved. I think that there were cases when we were 10 years ago where people were arguing about really text messages, but that's a settled issue. And some of the very recent cases I'm going to show you in a second, I think are going to underscore what I'm talking about. But there's not really much debate anymore about the importance of preserving text messages. So it's something I think everybody would be prudent to advise their clients to think about in advance, that text messages should be preserved.
Are you doing any, Patrick, as far as that goes, are you doing anything proactively with your clients, like downloading their cell phones immediately?
It's a fantastic question. I am, once we believe litigation is afoot. But I'm not doing that with respect to just as a matter of course, because my view is, and I'm going to talk a little bit about this in a couple slides. My view is that some deletion is part of being a corporation. Some expiration of data is just part of the life cycle of a company. Going back to Discord, if we had to preserve all Discord messages, companies could potentially triple, quadruple their cost with respect to electronic data. It's just that expensive to be preserving every video that goes across Discord. So some deletion is tolerable, provided it's reasonable and provided it's got some sort of non-nefarious or non-litigation focused point. I think people switch phones, people forget to back up phones, but I really want to hit this case involving GoDaddy in a second, because this one is kind of blew my mind. But some data gets lost. And I think it's very defensible for me as corporate counsel to say, and I've succeeded in saying this, we did get an electronic vacuum and suck the data off the pertinent employees' phones once we believed litigation was imminent. We didn't do it as a matter of course. And so some data from 3 to 4 years ago is gone and there's nothing we can do about it. I think that's defensible, not only from an evidentiary perspective, but also from a discovery standpoint. So no, we're not, but I'm going to hit the cell phone point a little harder in a second, because I think it's an interesting question. So I really appreciate you bringing that up. Amanda, could you pump the next slide up? So here is the cell phone comment here. What we're seeing in terms of scope, particularly from companies, hinges on obviously the first three concepts we learned in civil procedure as informing a discovery obligation: custody, control, possession, right? And the magic where all the money is made around the concept, litigating the concept of control. What does it mean to have control? And there are different approaches. The two prevailing approaches that we've seen are legal right. Does the company or does the individual have a legal right to get the data? The more expansive view, where I'm from, California, and the Ninth Circuit does not follow, is does the company or the individual have the practical ability to get the data? And it's an important distinction. And let me explain a little bit about what that means. Legal right means that I am allowed to do it by some statute or by some contract, that I could point to some source of law or practical pertinent authority that allows me to make the request and obligate somebody to fulfill it. Practical ability could mean something bigger. GEO and I were talking, I mean, if you demanded from your admin that she show you her personal phone at pain of being terminated, he or she probably would, right? So practically, you might have the ability to go through the personal cell phone of somebody at your law firm, but that's not the legal right to do it. Now, I gave a pretty extreme example, but the point is that you want to be mindful about which jurisdiction you're in, because different standards are going to inform how broad the obligation is. I like where we are in California, because I put the pressure on the other side. Show me a statute, or show me a document, or show me an operating agreement that says that we can do this. And let me talk about this specifically in the phone context. It was really popular and really sexy when the Silicon Valley was just explosive a few years ago to give out free phones, free data plans. Well, you can imagine where I'm going with this. Because the companies own the phones, the companies had access and the legal right to access the data. And so you can imagine what that does to a company's discovery obligation. They suddenly are in a world where they are a steward of all of the data on workers' personal phones. So what did companies do to get around that? Well, then they moved to personal cell phones that companies would pay for. And then the argument to get around the legal right of accessing the data on those phones sort of seemed like a harder one to make. And it looked something more like, the argument on the other side was more, look, it's a personal phone. We just pay for it. That's it. One more iteration to this ongoing debate, at least out here in the Silicon Valley, is informed by a company's data usage policy. You guys are probably all thinking, why is Patrick rambling about this? But this is sort of the punchline. It's very common for companies to include in data usage policies, employee handbooks, terms that say we can access your phone anytime we want. And they do that as almost like a deterrent and as a mechanism for potentially setting up a some type of vigilance with respect to confidential information, right? But the problem is that then can create and has created, and courts have recognized, at least in California, the legal right of access. And suddenly a personal phone that has work data on it is now part of the scope of what you as a company need to preserve. So it's just something to think about, right? Like sometimes companies think that they're doing themselves a big favor by having overly strong data use policies, but in reality, they might be doing themselves a disservice from a discovery standpoint. The same thing, but with a different shade, is true with the different messaging platforms that companies use. Again, Slack is probably one of the bigger ones. Jabber is another big one that companies, particularly out here in the Silicon Valley, are using. And there's an important issue here with respect to, is it something that the company takes sort of a proprietary control over, or is it literally all being outsourced? And this is all going to be defined in your agreement as a company with these different platforms. Sometimes you actually get like a proprietary version of the software that you are the custodian of the data. And you can imagine what that means. That means the Slack data is indisputably within the scope of your control. You have a legal right to get it. And so then it becomes a part of your discovery obligation. Slightly different when it's a Slack platform that is being run by Slack on your system, and you don't have the ability, you don't have the right to just pull data at your choosing. But this is another example where you want to think through multiple chess moves, right? Because what's going to happen if you counsel your client, hey, this dork from California came on a Zoom the other day and said, if we have Slack outsource its services and don't take control of the data, we're not going to ever have to produce it. Well, what's going to happen? I think you know. A subpoena goes to Slack, and the subpoena goes to Slack, and the only hurdle that then needs to be cleared is you're going to have your client sign an authorization, which courts oftentimes will compel. And then you've got Slack lawyers who don't want anything to do with your case, producing documents in response to a subpoena that you might have been able to be a little bit more vigilant and diligent with if you were the person and you were the team handling it. So, it's something to just think through. Maybe it expands the discovery burden, but if your client is not bootstrapped, if your client actually has the resources to fund litigation in a smart and thoughtful way, it might be better to actually maintain more control over the data. And just as a footnote here, I think the best place to find cases about this particular issue pertain to parents and sub relationships. That's where I always go.
I'm sorry, what was that, Patrick?
Parent and sub relationships. It's a different context, but that's just an area that gets litigated so often. Can the parent get documents from the sub? And so that I use that sort of as an index marker for me when I'm trying to get myself smart on this particular issue. But Amanda, maybe you could pop to the next slide if that's okay. So the evidentiary consequences, right, of failing to preserve documents. I think people probably know these. There's three principal consequences that courts will impose here. And again, I'm not telling you anything you didn't learn in first year Civ Pro, but there's monetary, evidentiary, and terminating sanctions. And I think if we were to curve the typical outcomes here, we would see that the center of gravity tends to be closer to evidentiary sanctions. Not super common to see terminating sanctions, but it is something that has happened. It is something that I think you want to be thinking about in this context, particularly if you're wearing your defense counsel hat. If plaintiff destroyed the laptop, right? If plaintiff destroyed the cell phone, there are better pathways to getting terminating sanctions than you'll get when somebody, in some of the examples we talked about earlier, where someone forgot to preserve a phone just generally, or somebody didn't preserve or ask employees to preserve, Tinder communications, like in my silly little example. I think I mentioned to you earlier, California courts though have a different standard as far as when those type of sanctions are in play, but those are real big deals, right? I mean, you can imagine a tough conversation that you're having with the client.
Well, Illinois, interestingly, Patrick, under Illinois law, the sanction usually comes out as an adverse instruction.
Interesting. which is devastating.
Illinois pattern jury instruction 5.01.
Oh, wow. Hey, now I see why this is lunch with Geo. You're the man here. You've got that right at your fingertips. I like that. That's good.
Been there, done that. That's
Oh,
all.
okay. I like it. Amanda, can we go to the next slide, which I thought were they were just recent cases that I wanted to talk about here, just because they sort of show some of the points we're talking about. This is a case from last week. And it's from the Eastern District of Pennsylvania. And it was an interesting case because the debate was about this Discord issue. And they were going on and on and on. And this is what prompted me to ask the young folks in my office, what the heck is Discord? But Discord had all of these different types of communication available to it. It had text, it had video, and it had audio. And defendant was saying, wait a second. When did it become our obligation to take on that much data? And we always have been deleting it. And of course, we're going to continue to delete it. We don't have the server space. We're a smaller company. The argument survived a sanctions motion, but the court ordered further discovery on the issue for, I think, exactly what Gio was talking about, for the potential purpose of establishing adverse jury instructions. And so it's a different thread here. Just because maybe you get out of the woods in terms of a per se discovery violation doesn't mean that you might not have other types of consequences on the horizon. And again, the other point that I think you want to be thinking about here is asking those questions. Do you actually do a lot of your communication through Discord? Is that smart? Is that good business? You'd be surprised at how many young companies do. The other argument that potentially got them out of really serious sanctions in that case was the one I was just making a moment ago. They didn't control the Discord platform. The other platform did, right? Discord controlled it. This was not a situation where there was like a bespoke version of the platform that Steam ended up taking on. It was a different sort of arrangement. Now, that begs a really interesting academic question that I have not seen courts debate. But do you, as the defendant in a case like that, have an obligation to send a preservation notice to a third party? I have not seen that litigated, but I think, let's put our enterprising plaintiff's hats on for a moment and think about why that makes great sense. If you are that company that knows that it can minimize its electronic footprint by keeping those communications somewhere else, doesn't it seem likely that you probably have an obligation to actually remind those companies that, hey, you shouldn't be deleting data either? Again, this is an argument. It's a creative one. I haven't seen it play out in the courts, but I think we should be thinking about it. The next case, the Drips case, this one is from a couple weeks ago, Northern District of Ohio. And this had what Gio was talking about a moment ago, a mandatory adverse jury instruction. And here's what happened in this case. It was a trademark case. And there was a trade secret piece to it as well. The defendant, 10 months into the litigation, it was really interesting. 10 months into the litigation, changed the retention settings from being indefinite to 1 week. And it was interesting because one of the arguments that the defendant made was they said, look, this is a trade secret case with a trademark case with a trade secret piece. And everybody keeps talking over and over again about the importance of confidential information. And so we thought that it made sense to sort of change our settings because we wanted to be respectful of well, the judge didn't buy it. And there were a series of adverse jury instructions that came out against the defendant that I think are an important reminder about this type of gamesmanship. We don't want to be doing that.
How late did those lawyers stay up thinking about that excuse?
I like that. I can picture lots of cups of coffee, 1 in the morning around. I got it. And just by way of reference, it's an unpublished case, but I did really appreciate the discussion here. In the sanction context, there's a level of culpability that needs to be shown, and it's more than carelessness. And in this case, the court was very bothered by how late in the litigation this move was made, how much discovery had taken place, how much conversation had taken place about discovery obligations, and yet this still happened. But it's something to remember. If you are in that boat where somebody had a foot fault on the client side in terms of preserving documents, it's important to know, hey, there is a mens rea requirement here, and we can potentially buy us a little bit of breathing room if we're able to show that this was just clearly a huge mistake and not something extremely reckless or intentional. But the Bonds case kind of hits a different point. The Bonds case was a pro se litigant who had a really interesting case. He was denied access to a local football game, and he brought a series of civil rights claims. So it was kind of all over the place. He actually asserted, and I thought this was an interesting question, he asserted a standalone spoliation claim on its own as a tort. I'm sorry, excuse me. The school and its counterclaim asserted a standalone spoliation claim as an independent basis of relief. What the court said was that under federal law, you don't have a standalone spoliation claim, which I thought was interesting because in California, people assert that all the time and argue that you do. But the one little piece here that I thought was really interesting was the guy deletes his Instagram account. He doesn't get sanctioned. And the reason he didn't was because the court was not convinced that there was any nexus to his injuries, to his experience at the school, or anything relating to his damages. Some type of showing the court was looking for to be made about why some type of deletion actually materially impacted the litigation. Now you can imagine what the school said. How can we do that? It's been deleted. And so they're throwing out hypotheticals. Well, it might have shown, he might have put a video up right afterward where he talked about the experience. And the court said that's just conjecture upon conjecture. Now, reading between the lines, I think some people probably are thinking, well, maybe the court was giving this guy, a pro se litigant, a break. And just, spoiler alert, all of his claims were dismissed in the same decision. So you can understand why maybe the court was giving him a break on the spoliation piece. But I do think it is a reminder that, like we talked about at the beginning, just because a repository of information exists does not mean you necessarily need to preserve it. You have to apply your judgment. You want to have those conversations with your client, et cetera. Now, this last case, not as recent. It was from January of 2022, but I was just fascinated.
This is an amazing case.
Have you seen this one before? It's just blows my freaking mind. And it's got a couple layers, and I really thought that the judge did a good job of going through it analytically. The spoliation claim touched on 5 different things or 4 different things: Facebook posts, unsent Facebook messages, which I thought was just so interesting, iPhone data, and then Telegram messaging. The Telegram messaging wasn't really interesting for our purposes, but it is interesting from the standpoint of that's just one more tool, guys, that we have to be thinking about. One more thing that's out there. It's a popular encrypted, I actually did work for them when I was at Skadden, a popular encrypted messaging software that people are using all the time. So it's one more thing that we need to include in our little checklist when we're deposing somebody, when we're talking to our clients. The Facebook post, deleting the Facebook post, the court definitely thought was spoliative. But the 2 that were most interesting were the unsent Facebook messages. So this was the plaintiff in a Facebook communication pulling her own messages back, deleting them so that the other side couldn't see them. And the defendant argued successfully that that was spoliation. Very interesting type of spoliation, right? Because you're deleting it from somebody else's server and your server as well. So just kind of different. And it does hit one other thing that I want to flag, and I don't know the answer here, but on LinkedIn, this unsending of messages issue exists as well. So just be thinking about that a little bit. And so here's a real world example that I've confronted where one of my clients is in the business of providing educational services to students. And so obviously what's relevant and is requested a lot are complaints from students. And a lot of that business takes place over LinkedIn. Well, do I have an obligation to prevent someone from unsending LinkedIn messages? Do I have an obligation as the defendant to preserve that data for all time because of the risk that somebody might end up unsending a message? I don't know. This is something I've been thinking about a lot, but it's something that I think good lawyers like the folks on the Zoom should be mindful of. Even if there's not a great answer, I think being in a position where you can have the higher ground of reasonableness in front of a court and say, didn't know this was happening, so didn't take those steps, or did know it was happening, but didn't think it was material because of X, Y, or Z. Having that sort of that forethought, I think, is helpful. But the most interesting part, and I think GEO was probably hitting this one, is this just blew my mind. The plaintiff's phone was stolen. I mean, I think first-year torts, right? Isn't that like third-party intervening criminal conduct? Doesn't that usually alleviate a defendant of liability? Well, what the court said was litigation was likely, and you had a pattern and practice of uploading data to the cloud. and yet you stopped doing that after the litigation commenced. So again, maybe reading between the lines, let's take a step back. Maybe the court was actually saying, I don't buy your excuse that the phone was stolen, right? Because imagine how many, if the contrary rule was announced that, hey, your phone gets stolen, it's a get out of jail free card, you could imagine how many thefts would take place with quotation, with the air quotes.
After litigation started.
Pardon me?
After the litigation started.
Exactly, exactly.
Hey, judge, the dog ate my homework.
Exactly. It'd be, you'd probably hear that 10 times a day. So there may be a view that the court was being a little tougher on the plaintiff, but it's something to be thoughtful of. And again, you could connect this with the Drips case by up leveling here a little bit, which is whatever you're going to do it regularly and do it based upon principle. Not a good look when you're moving the goalposts in the middle of litigation or in the middle of like the problematic time period, right? If the plaintiff had never uploaded data to the cloud ever in GoDaddy, you could imagine the court not articulating that rule. Just as if the the defendant in Drips had always had the 1 week auto deletion rule, you could imagine the court saying that's not ideal, and that might be ripe area for cross-examination. Why would a company ever do that? But probably going to be tougher to build a sanctions case. So I think an extractable point from these cases is just this idea that if you're going to do something, try to do it regularly. And I know we're tight on time, so Amanda, maybe we'll go to the next slide here. Even if you can get out of sanction territory, though, don't think that you're necessarily in the clear, because as we were talking about a moment ago, this is the hotbed of evidence. And I think a lot of criminal lawyers will talk about how the TV show CSI, when it first came out, created this expectation among jurors that forensic evidence would be so precise. There would always be hair and DNA at the crime scene. And a lot of prosecutors were really frustrated by that. The analogy that I'm trying to draw here is jurors are now expecting to see text messages. Jurors are now understanding that in their own lives, their communications are so heavily digital that for somebody to come up and to come to the stand and say, I don't have a message that says this, or that said, or I deleted it, as a matter of course, or there is no documentary proof. I think that there's a growing skepticism, at least out here in the Silicon Valley, that that's true. So even if I'm not getting monetarily, evidentiarily, or terminatingly, I just made up that adverb, sanctioned, there's still going to be a problem of proof. There's still going to be a problem of evidence. People get suspicious, especially when you have that type of expectation. I mean, who hasn't been in a depot where an email says something like, let's take this offline, or call me, and the questioner spends 15 minutes. Why'd you do that? What does that mean? What were you trying to insinuate, etc. So I think just thinking about that, it is important, because just because you're not being sanctioned doesn't mean you're in the clear. And it can mean a couple different things. A moment ago I was talking about, well, what if Drips had just had a 1 week auto deletion policy? Sure, maybe that bolsters their anti-spoliation sanction case, but you can imagine the problem that it creates in the minds of jurors. What kind of company deletes everything every week, right? That just doesn't pass the smell test. So when we're putting on our consigliere hats, not just our litigation hats, that should be a consideration that we include in the discussion. And just the other side of the coin here are ephemeral messaging communication systems. That's like Snapchat. And there's quite a few of these out there. Telegram and Discord all have those functions as well. Well, you could imagine a short-sighted inside counsel saying something like, okay, I just heard all this stuff about discovery burdens and smoking guns from Patrick. Let's just go to Snap, right? Let's just make it so nothing is kept. Patrick talked about being consistent. Patrick talked about being regular, not changing. Well, if we're just on Snap, or we're on Telegram Secret, that's what they call it, then we're never going to have to produce a document ever again. Aha. Well, that type of myopia might be punished by jurors. We're going to expect to see some type of documentary record, some type of contemporaneous memorialization of the issues that are in dispute. So just include that in the opus of considerations when you're having these conversations. One more slide, Amanda, if that's okay, and then I think I'll wrap up. This will be sort of quick here, but you also want to be thinking about admissibility and excludability of social media and text message communications. And I think the shortest path from document to admissibility is actually like what GEO was talking about at the beginning of our call, which is using vendors who have technology that can be backed up with a declaration that they pulled it off Twitter in a forensically sound way, and that they can prove when it was pulled and have it date stamped. That's the easiest way to get there. But I think we've all been there where before a deposition or when you're rushing to prepare a cross-examination outline, you're going onto someone's Facebook and just printing it out. And I think we all remember from third year, second year evidence class, the standard for authenticating any type of evidence. You have to produce evidence that is sufficient to support a finding that the item is what the proponent claims it is. You don't need to prove beyond a reasonable doubt that a Facebook post put up by GEO is a Facebook post by GEO. You just have to meet that sort of threshold standard. But unsurprisingly, some courts have remained a little skeptical about social media that's just literally printed off the internet. Maryland, some courts have broken it down to a Texas and a Maryland approach and have followed them. The Maryland approach is a little bit more skeptical. And one of the seminal cases there involved a criminal case where the defendant had allegedly posted on MySpace, which I don't know if anybody remembers MySpace, but that was one of the predecessors to all of the things we're talking about. Snitches get stitches. And it was just printed out by an investigator. And it had like the investigator's footer on it. And it had all the indicia that it came from the investigator's home computer and internet searching. And the Maryland court said, you got to do more than that. You need to prove to some extent that there aren't other creators here. And that's sort of the minority view, but was the prevailing view when this proliferation sort of exploded. Texas, people call it the Texas approach, is more lenient. And the idea is weight, not admissibility. Let the jury decide, not the judge. And typically you're going to be just fine where there's some type of circumstantial indicia of authenticity, seeing a logo, seeing a handle, seeing pictures that connect the post, a profile picture that connect GEO's post to his image. Typically you're going to be just fine. But it is an area where, again, do you want to bank on that? Let's say you find that smoking gun tweet. Just one quick side story. I represented a scraper against Craigslist years ago in a case involved a complicated case, but they had an expert who came in and talked about Craigslist and its intellectual property and the value. And she had tweeted, she was a real estate agent, that Craigslist is filled with spammers and scammers. And it was a disqualifying tweet. It was just absolutely disqualified. She could not testify because of that. And we had to dig very deep to find it. But do you want to take the chance of the Patrick Hammon email footer being on the top of that email, or, it's a black and white document and that's all we got, or I didn't, it's up to you. It's up to you. I would submit that there are vendors out there who can do this the right way and can do it on the cheap and can do it in a way that the right indicia are placed on the document. And again, there's usually a declaration that gets attached to it or can be provided with it so that, it's not Patrick Hammon who's become a witness that, yeah, I saw this on Twitter and I printed it out. I sent it, that sort of thing. So concluding thoughts, Amanda, I think is our last slide here. Be careful, right? We talked about this. Be careful. You have to be thoughtful and you have to be thinking about all the different places where these type of communications are taking place. You do not want to be an ostrich. Gone are the days. I don't care how many years you've practiced. Judges are going to expect you to understand that communications are taking place in these other channels. And this is me really talking to my dad, who says, I don't know what Facebook is. I don't know what Snapchat is. It's me saying, it doesn't matter. The judges do, and they're going to expect you to be thoughtful and careful when you're undertaking your preservation obligations. Be creative. This is more a comment for litigation strategy. Think about where the smoking gun might be hiding. People are a little bit more careful. Remember that curve we talked about with what they're putting in email. So let's think about where we can find the Tinder chat that we were talking about, or I believe it was a text message that GEO was talking about a moment ago that he found that was so critical. And then be proactive. And this is something I think we've talked about over and over again, which is the idea that, don't wait for litigation to get your arms wrapped around this. Don't wait for litigation to start thinking about the right way of potentially setting up your company's custodial practices with respect. Security is literally busting down my door. This is just delightful. But don't wait until a complaint is filed for you to start telling your client, hey, you know how you were recording every single Zoom? That could create an issue here for you. It could create an issue, not only in terms of now needing to preserve it for all time, but how careful were you, in month 9 of the pandemic when I think everybody's hair was growing all over the place and we hadn't seen anyway, be proactive in managing those conversations. And that's sort of where I'll park the ship here.
Patrick, thank you.
Oh, thank you.
That was one of the most articulate, well put together programs I've seen on this subject. Thank you very much.
Thank you very
I can
much.
see now why your firm is charging your clients $1,400 an hour.
My old firm, not my new one.
Oh, okay. All right. All right. Would you stop sharing?
Yes.
All right. And I'm going to share my screen now. And remind everybody that in 2 weeks, it says Wednesday the 12th, it's actually the 26th. We're going to talk about the metaverse. Imagine that. We're going to talk about the metaverse. Nelson Rosario, who is an adjunct professor at Kent, is going to be speaking on it. And if you want CLE credit, here's the key. Send an email to attendance@nwsba.org. Subject line, thank you, NWSBA, and include your full name and your ARDC number. And with that, I'm going to say thank you again, Patrick and Amanda. It was wonderful. The PowerPoint is going to be shared. The recording will also be put on the NWSBA website. And with that, I'm going to say to Patrick, come to Illinois, the home of—
Oh, I'd love to.
The home of BIPA.
Would love to. Thank you for welcoming me into your homes and your Zoom, and I hope we can stay in touch. I'll just throw my email into the chat just in case anybody wants to ever catch up. And if you're ever, truthfully, new friends or old friends in my book, if you're ever in San Jose and need a place to park it for prepping for a depot or taking a depot, come by my office.
Oh, certainly. All right. And Amanda's going to help us then.
Oh yeah, she's
everything.
Right. Thank you, everybody. Take care.
Wait, no, we're not done yet.
Oh, I'm sorry.
Does anybody have any comments? Gary Searing running for judge. You want to say anything, Gary?
Well, it was very fascinating. I appreciate the presentation, and I'll take it all with me on the bench.
All right, attaboy. Any other comments? President Ken?
Thank you to Patrick and Amanda and you, Geo. This was a phenomenal presentation.
Thank you.
All right. Anybody else? Any snide remarks? Funny comments?
We'll leave
Jokes?
those in the chat.
Anything but a dad joke is acceptable. No groaners. Okay, we have nothing else to add. I'll see you guys tomorrow night for our candidates forum. Gary's going to be participating. And with that, again, Patrick, Amanda, applause, applause, applause.
Thank you. Thank you, everybody.
All right, Patrick, be well.
You too. Take care.
All right.